and get started. Obviously, this is Lewis Longman and Walker. My name is Richard Green. I'm in the St. Petersburg office, doing mostly work in litigation, environmental, and real estate. Over in Jacksonville, we have John Wallace, who will tell a little bit about himself shortly. And down in West Palm Beach, we have Andy Bauman, who also discuss a little bit more about what he does. Today, the idea here in discussing riparian rights is to give somewhat of a state of the union on riparian rights and interests. We're going to break them up into four categories and answer, four questions, and they kind of go along with what are riparian rights, which most of us here probably have an idea of what they are, so we'll touch on that. The next question I'm going to ask is, when do you have them? And that, obviously, there is a distinction there, and that's important, but also that kind of takes care of the first question is, disputes over whether or not people have them in the first place. The third question we're going to ask and go over is, where's the box? And you'll understand that question as we go through the presentation. And then the last question we're going to ask and answer is, whose box wins? And this, again, will be more understanding when we go through the presentation. And we're also going to be talking about the disputes within those questions. So if we can move on to the second slide. Tyler, I think you all have control of the PowerPoint.
Yeah, working on it. But the button's not working. There it goes.
All right, so obviously the first thing we have to discuss is what are riparian rights, and generally I think we all have an idea, but riparian rights are those incident to land bordering upon navigable waters, in layman's terms, that is land that touches water. But then the next part of it is they are rights inuring to the owner of the riparian land but are not owned by him or her. What we're saying there is there are rights in use of the water, there are special rights over and above the general public, but you do not actually own the land. That's different from, the owning the dirt that touches the water. And they are pertaining to and inseparable from the riparian land. You have rights, again, you have interest, but once you no longer own the upland, you no longer have those rights to go with it. The rights stick to the dirt that touches the water. The listing before there, listing after that, ingress and egress to and from, boating, bathing, wharfing out, and view. But all of these particular interests are subject to the public superior right of navigation. So as you're going to understand in this State of the Union, there is a push and pull, there's a conflict between everyone's interest in the riparian area that is being weighed. So it's not an outright trumping when we're talking about these various rights. And the one that we're seeing right now, the trendy dispute is over view. When someone has land bordering the water and they look out, they see things happening to the left or to the right on their neighbor's property, and they believe that obstructs their view, which is technically correct. And that brings us a lot of complaints and things that we have to deal with. But these are tough cases to litigate or to manage, because the right to a view does not mean the postcard, the 180 degrees unobstructed view. And as out there doing work and you're maybe building a dock or something along those lines, keep in mind that the person next door may have an issue with what is being put out there, but also understand that the right to a view is not an unobstructed view. Again, it's an interest that has to be weighed.
There's also a hierarchy between these rights that's been loosely recognized by the courts, and view has traditionally been one that's fallen to the bottom over access, ingress, egress, that sort of thing, wharfing out even. What you're going to see in a recurring theme in all of these disputes is that basically any time you or your client does anything in his riparian area, by definition, he is interfering with somebody else's riparian rights. It's just, it's as inevitable as drawing breath. So the point is that interference is assumed. It's, the case law, the test is when that level of interference becomes unreasonable. And so it is a squishy area, and there's a lot of weighing and balancing of fairness. So that makes view a particularly difficult one. We've seen a lot of view cases coming along lately, particularly with the advent of these and the proliferation of these large capacity boat lifts that are lifting, in many cases, 40-some-odd foot boats up to high level on the seawall and enraging the neighbors. It's not the same thing as having a 40-footer in the water as it is when you walk out and you're looking at the slab side of your neighbor's 41 Bahama bow jutting out into your view. So we've seen a lot of these, and I probably, hardly a day goes by that I'm not counseling somebody that view does not mean a postcard, welcome to Florida, and that you're entitled to that. Your neighbor's entitled to his boat lift as well, and it's only when that becomes truly unreasonable that we run into a problem. So, next slide, I guess.
So now we ask the question, when do you actually have riparian rights? There's probably everyone in the room and on the phone understands there's a misconception that just because you own house on the water, that must mean that you have riparian rights, which is not necessarily true. The first prong of that question is that your land must actually touch the mean high water of a navigable water body. And the navigability, as we see here, says determined as stated. That doesn't mean that, Florida went around and did all this back in 1845, but what it means is that navigability, the water body had to be navigable at the founding. The issue gets different when you're talking about artificial water bodies and privately owned water bodies, which I will punt over to Andy to go in more detail and bring us to our first case.
All right. So there has been a traditional rule in riparian rights that owning land fronting on an artificially created, privately owned water body does not confer upon you riparian rights. That case really comes from a case called Public Supermarkets versus Pearson, which is from back in I believe in the 70s. It involved a former phosphate mine converted into a lake and then subdivided into a neighborhood around it. Publix bought some land on the lake and wanted to fill a big part of the lake for a supermarket. And the owners, abutting other portions of the lake, sued, arguing that their riparian rights to use the lake and navigate across it and whatnot would be interfered by Publix's activity. The Second District Court of Appeals conducted a fairly good historic analysis of the distinction between navigable waters, meaning navigable in fact on March 3rd, 1845, versus artificially created waters, and came down on the grounds of, since riparian rights are in reality common law created, codified statute, and the statute did not do anything to expand upon it. What we're talking about in riparian rights is essentially a water body that's navigable in in fact in its natural state at the point that Florida entered the United States. We get a lot of claims, as I'm sure most of the people in this room and on the phone have run into from time to time, particularly about dead ends of artificially created canals. And we probably have 3 or 4 of those disputes going on at any one time. And to be honest, those cases tend to resolve themselves more on the grounds of right-of-way regulation and the law of plat dedication than they do on riparian rights, because these people don't technically possess riparian rights on those artificially created canals. They may, however, be granted the rights in some other similar rights. We'll call them riparian rights in some other instrument. I know the city of Boca Raton actually just in the last couple of years adopted a very extensive ordinance. They got tired of dealing with dead-end canals and all the problems that ensued. So they adopted a fairly extensive ordinance regulating docks and wharfing out and access in canals, and their rules on where people can wharf out and build and views and whatnot looks very much like common law riparian rights just restated into an ordinance. So they took it, they put it into an ordinance, and now regulate all of the man-made canals in Boca through that process.
A question, how different is navigable, in fact, in Florida law than navigable under the Rivers and Harbors Act of 1899? Because those navigability determinations could happen any day. They could happen today.
There has been some when the navigable in fact test first came out in Florida, there was extensive review of the term navigability in federal law. So it's drawn on federal law considerably. Navigable, in fact, in Florida does not mean like a substantial boat crossing water.
And neither does the federal law.
Yeah. So, I mean, there's a very famous case out of the Panhandle that everybody calls the saw log case, where you're floating logs down the river, and that's navigable. Running a traditional kind of cram-type boat across a body of water, that's navigable. It may only be a foot or two deep. And that's been pretty consistent with the federal regulation on it. And then in Florida, the trick here is that you're trying to figure out, was it in that condition in 1845 when Florida became a state? So you have another part of the equation that you have to satisfy at that point.
So I guess my question about the potential confusion, it could be a federally navigable water under the Rivers and Harbors Act,
Correct.
Federal law, but it might not be because it wasn't in that condition in 1845.
Absolutely, and it does not equate to, quote, waters of the state or waters of the United States from a regulatory standpoint. I think United States versus Ray expanded the federal regulatory jurisdiction into artificially created water bodies. Ray was a case where they were building a boat basin. It was not connected, and then they connected it to the adjacent waterway, and the court in that case held that once they connected it, boom, it all became waters of the U.S. for the purposes of regulation. Here we're talking from a common law standpoint, not a Clean Waters Act statutory interpretation.
I'm just going to interject here. Where you're going to run into problems with clients who desire to build a dock, if on an artificially created water body, is where if you look at the plat that their property is located on, or in that case, if the canal is not shown on the plat, you may end up encountering an issue there, because courts have held in that situation, if the canal is not shown on the plat, it may not, the people on that plat who, in fact, front the canal may nonetheless not have any right to build a dock into the canal.
Or alternatively, the person downstream, if you will, may have complete freedom to do whatever in that canal. Here's his neighbor getting past him to get to the water. There's another case called Pearson out there that actually deals with that issue, and Mr. Pearson was blocked from reaching a national lake, and the court said, too bad. The other side of do you have riparian rights that's been a recent development is the 5F versus Dressing case. Probably the most talked about riparian case in the last 5 years. The 5F case is really fascinating. This is an aerial of the neighborhood and the property that was at issue in 5F. And the fact of the matter here is that most these lots, these platted lots which you see here, occupy what was largely, formerly state-owned submerged land. And some considerable time in the past, some of this land was conveyed out into private ownership. And it was conveyed out, if you will, in this shape that you see out here at the top, this outermost part of the plat. So you have these numbers here, which you see are oddly shaped parcels with this wavy line. These are actually platted lots. But the developer filled into this particular area, and it was agreed upon by everyone that this yellow line that you're seeing here represented mean high water line. And that mean high water line was agreed to by both parties in the litigation. And it was agreed to that the Dressings, which owned this parcel right here, parcel 1130, that parcel touched mean high water line. However, the developer still held these other lots out here in the mangroves and out in the water. And the Dressings came along and built a dock, and they built, you don't see it in this photo, but they went ahead and put the dock out there, and the developer didn't object, nobody did anything, and at a later point in time, the dock, which is in the parcel highlighted in blue, which is owned by the developer, was objected to by the developer, 5F Corporation. And the gist of the case was, wait a second here, this guy may own to the high water line, but 5F, I own the land below the high water line here, and I don't want this guy's dock on my property. And the court ultimately held that in 5F, in something of a slight shift, that the Dressing lot, by virtue of the fact of touching the mean high water line here, was possessed with riparian rights, including the right to wharf out, and that this happened regardless of who owned the underlying water. If it was a natural water body, distinguishing from Publics and the other cases about artificial canals, if it was a natural water body, it doesn't matter if 5F owned it, it doesn't matter if the trustees of the Internal Improvement Trust Fund owned it, it doesn't matter if anyone in this room or on the phone owned it. The Dressings had riparian rights that gave them rights across another private party's land. It is interesting, this is an example that we so often see of bad facts making bad law. 5F, of course, marketed these lots as lots. Sold to the Dressings, who then built their dock to gain water access to their waterfront home, and then the very developer who was happy to take their money turned around and wanted to eject their dock, and I think in large part the circuit court and ultimately the second district court didn't like that very much. And I think they were kind of looking for get where they wanted to go. It is interesting that the Dressing court is the second district court of appeal, the very same court that decided the Publics case. So the same court that told us no riparian rights on privately owned land is now saying, on artificial privately owned land, is now saying that riparian rights attach to submerged land between navigable waters regardless of who owns it. So how do we get these two cases to combine? The only distinction I can find, number one, is that this was a navigable water body out in here that was private ownership versus the Publics case, which was an artificial. And that's the only way to divide these two cases in court. The other thing that's kind of interesting in the Dressing case is that it was undisputed that the dock that the Dressings were putting in did not extend beyond the low water line. So the Dressing court had an interesting twist on its ruling, stating that the riparian right held by the Dressings over the private 5F submerged land included the right to wharf out onto this private land as far as navigability, or it said, but no further than the low water line. So I find that kind of interesting because I don't know how you can have a dock warping out to navigability if at at the end of your dock, it's dry land at low tide. But the court kind of sidestepped that issue. Reading the case again and again, I can only think that they were trying to tailor this decision very closely to the dressings dock and trying to, if they were opening the door into something new, trying to open it as little as possible. I know that the dressing case is still going on because on top of everything else, the land out here in this water has started to accrete. And now they're all fighting about whether or not 5F is losing land to the dressings or not, and that case, as I understand, is still...
It's only accrete to uplands. So if 5F only owns submerged lands, they cannot benefit from any accretion. That's
Right. It would be
That's right.
Dressing.
That's right.
Yeah, the question is whether, as the land accretes, whether the dressings lose their land. Whether 5F loses its land.
Well, the accretion rule does not really distinguish between the owner of whether the owner of the land below the water is the state or a private individual. The accretion rule is triggered by the property line being at the high water line. And that line, as we all know, is ambulatory, as we'll see in another case down the road. So I don't think it matters. I mean, my own take is I don't think it matters. I think that whether the dressings own it or the state owns it, if it accretes, the dressings gain and 5F or the state would lose, and vice versa. If it eroded, the dressings would lose and the owner of the submerged land would win. But I think the controlling factor is not who owns the land below the water, but where's the property line drawn? Is it drawn at the high water line, or is it drawn at a fixed point on a plat? And I think that you would get different results based upon that distinction. So 5F is still out there. We haven't seen it applied a lot yet. It's not sure. I'm not sure where it's going to get applied. We have a reasonable idea that it might be applied here locally before long. There's a big dispute going a little north of West Palm here, where you might see 5F come into play. So stay tuned on that one. I think the effects of this case are not yet fully understood. The next case I'm going to yield. John, you got the controller?
Yeah, I got the conch, I guess.
Got the conch? All right.
Yeah. This, I'm John Wallace. I'm up in Jacksonville. This is a relatively recent riparian rights case. It's called Shadow Point v. Colgan. This began as a dispute between Mr. Colgan, who owns this house, and Shadow Point, that owns this house, over who owned and had the right to use this dock right here. Basically, what was occurring is that this is a rental property. The tenants here would occasionally park their boats along in this area adjacent to what, just looking at it, looks like a marginal dock to Shadow Point's property. And it would block Mr. Colgan from accessing his boathouse, which is right here. As a result of that, Mr. Colgan said, well, I'm going to build a fence. And he built a fence running down the dock here to block people using this property from docking and blocking his access. Shadow Point sues him, basically asking a court to require him to remove the fence and to quiet title in their favor to the land underlying this dock. The dock was partially built upon filled uplands, and then obviously it extends out over the water. And ultimately, what occurred is that the court noted that this property was all at one time in common ownership. It was the common owner who had actually filled all of this property here. And there was basically some conflicting evidence as to where the property line actually was, and in other words, who owned the property, who owned the uplands that this dock ran over. And the court ultimately concluded that Shadow Point had not put forth sufficient evidence to prove it actually owned the uplands right here, and thus refused to issue the injunction to order the removal of the dock because they found that Shadow Point did not prove that it had riparian rights in this area. So in other words, it did not prove that its land touched mean high water such that it had a riparian right to use this dock.
The moral of the story is get yourself a good surveyor. If you need one, there's several of them on the phone and in this room, but it shows you how something as mundane as a nice, clear deed and survey at the outset of your case can kill you down the road, because otherwise you would look at these two parcels and you would look, for example, where that boat is docked on the side, that's part of Shadow Point's property.
The next case, this is kind of another case on the issue of it involves a lot of issues, but one touching mean high water. This is a case that's currently pending down in St. Augustine. We are handling this case. This gentleman here is a guy by the name of Mr. Marlowe. He purchased this parcel outlined in yellow in 2004 with the idea that he was going to subdivide it into several lots and put in a dock running right here with 6 boat slips to serve it. This neighbor, he and this neighbor right here ultimately got into litigation right off the bat. There was litigation filed in 2005. The case is still pending. But a few interesting things have come out of that case. The first is that this blue line here, this is the mean high water line. And this property within this region right here is kind of a no man's land. The county records reflect that the city of St. Augustine owns this, but it is not at all clear that any of these properties actually have riparian rights in this water body, which is Hospital Creek. I'll flip you to the next slide. This is actually the plat of this neighborhood. This plat was recorded in 1924. At that time, there was a road that was platted along here, which, as you can see, there is no road there. That road was designed to actually run down to the Fountain of Youth, which is down in this area. And the idea was that people would come in from Jacksonville across this bridge, would travel down here to see the Fountain of Youth. Ultimately, that road was never built. The city of St. Augustine disclaimed the road. But the developer of this neighborhood had, unbeknownst to anybody until this litigation started, had reserved title to all marshlands east of this bridge, east of this road. And so, as it turns out, title to this property is actually in a now defunct railroad company that was owned by August Texture. So the other interesting thing to note here is that, you know, if you look at this plat, you see this creek has 2 branches. As we started looking at, you know, the historical aerials in this, it just didn't quite look how the plat appeared, and so we started digging into those. This is an aerial from 1950. You can see how pretty accurate the plat actually was. You can see this bridge, which is shown on that plat. You can also see this little finger right here that comes in and touches just about at what is the city of St. Augustine's right-of-way. That would have been right about here. And so basically from 1924 to 1950, we see that there really hasn't been very much change. However, in between 1950 and 1960, the State Road Department came in, filled this large section of property, which is this property here, and realigned the Volano Causeway right here, such that it turns more northerly. You can actually see the roadbed of the old bridge right there. And so what you have is basically that the State Road Department destroyed or completely filled in the western branch of Hospital Creek right there. And so that has changed the calculus in terms of perhaps where this gentleman's riparian rights would even lie, which gets more in the where's the box question. He is claiming that his riparian rights exist right here. And basically the court has ruled that the gentleman who owns this property here, the city of St. Augustine, who owns a right-of-way right here and arguably has an unopened right-of-way to the water's edge over here, this gentleman and our client, this gentleman, were all indispensable parties to this action. And the relief Mr. Marlowe is requesting is that we tear down this dock, and presumably this dock, and move them all south so that he can have a 6-slip dock coming out right in here. We have not, we're still at the pleading stages, despite the fact that the case is 15 years old. So stay tuned on that. Stay tuned on that one.
I think it's interesting looking at this photo, though, that when you look at the yellow, the blue, and the red parcels, the thing that jumps out at you is, well, none of those properties actually touch the mean high water line. So the short answer here is that the city of St. Augustine has been giving permission to folks to build these docks across their property as essentially the riparian owner.
Yeah, and the question, that raises the question, though, given that we don't believe that the city of St. Augustine actually owns the property now. And so this gentleman has filed a quiet title action against the Toll Bridge Company. They've been defunct since the 30s. They were killed in the Depression. We are contemplating filing a same quiet title action, although his quiet title action does not actually vest title in him to the exclusion of us. It says that his title is subject to our claims. So we haven't done that yet, but if the litigation continues, we likely will.
So there's an example of how complicated the title questions can get on these things.
All right, so now we're going to assume that there are riparian rights, and the next question becomes, where's the box? Where is the riparian area for the upland owner? And what we're going to get into is, I think this is relevant to the people who are attending, is how the box has been drawn over time, but also what you do out there if you're surveying or if you're doing this type of work, or if you're looking for, if you're reviewing land deeds and things of that nature, you need to be asking the question how this may impact going down the road. So we have a very interesting aerial, and Andy, it just looks like it looks like the wild, wild west out there. People just put docks where they want them. Tell us about that case.
All right. Well, this is a firm favorite here, affectionately known in our law firm as the Leiden and Jordan case that we did back in the mid-2000s. This is Sewell's Point up in Martin County, and this is the Indian River Lagoon out here. Very wide portion of the Indian River Lagoon. It's more than a mile wide here. And you have a series of lots along the eastern side of Sewell's Point. And you can see you've got just complete disagreement over docks here. And one thing that doing a little digging we found was you can see that these three docks at the top of the screen are somewhat aligned with one another and in some disagreement, and that the docks to the south, with the exception of this oddball right here, who's just a little crooked, these docks here are generally in something of an agreement that way. And one thing that we found interesting here was that, as it turned out, the docks on the property at the top of the screen were older than the docks on the bottom of the screen. And that became a central point here. Just like the law can change at times, the accepted conventions of the surveying community can change at times as well. And very often when it comes to riparian rights, the two sort of join hands and change together. In this case, we have some older docks at the top here that followed, or roughly followed, the convention of the time, an earlier convention, which was that you drew your box by extending or prolonging your lot lines out into the water. And that was for some time, and you still see it today. Just draw their lot lines out of the water. But that methodology for setting lines fell out of favor, particularly in the mid to late 70s. The Supreme Court of Florida began to really criticize that methodology. The lines going as they extend out in the water in order to provide the owner with access to the navigable water really bear no relationship to where the owner's side lot lines were. So what would you do if you had, a lot that was an oddly shaped, square or something like that? Would you draw this riparian line up that way, and then this guy's riparian line out that way, and whatnot? And ultimately, everything is sort of settled under this scenario as being that you would draw your riparian lines typically based upon the principles of taking into account the shape or orientation of the shoreline and the arm of the sea. So taking those two things into account, you would draw your riparian lines, whether it be a cove where the lines can join something like pizza slices or pie slices, or the reverse of that, a peninsula could look the other way. And in cases of water bodies that are narrow enough, you would account for the channel, because the point is to get you from the dry land to the channel. So when we encountered the Lyden-Jordan case, we had a dock 500 feet long that went in this direction. We had a dock roughly 500 feet long going in this direction. I will tell you, Mr. Jordan's property was here, Mr. Lyden's property was here. And I can tell you that this photo does not do justice to how close the tips of these docks were. And you could throw a softball from here to there. And when these gentlemen here began to draw their lines, what we found was that this dock passed completely through Mr. Lyden's property, riparian area, and Mr. Jordan's riparian area. The lines were drawn something like that, and into Mr. Lyden's riparian area. The court ultimately concluded that and set the lines as perpendicular to the shoreline in this case. The reason being that this was a wide water body, so the location or exact direction of the channel wasn't as important here. What is interesting about this case, too, is that while you may get a result from the court that resolves part of the issue, then you've got the other half of the case to fight, which is, okay, great, the docks cross the lines, now you got to make the docks go away. And so at the point when we were at the remedy stage of the case, already having received a judgment recorded in the public record with coordinates for the riparian lines, the parties started talking and reached a rather odd conclusion, which benefited both this dock owner here by allowing him to save as much of the dock as possible, and benefited this dock owner here, Mr. Jordan, by speeding up the process by which he could ultimately put his dock in. And so as a result, you get a rather strange-looking solution that looks like that. This is the former dock that was sticking straight out. This dock was allowed to reach the actual riparian line. Mr. Jordan waived the 25-foot setback in DEP's rule, and that enabled a fairly substantial portion of the dock to remain, reducing the construction and replacement costs of the dock, and the dock was simply allowed to bend along the riparian line, and then Mr. Jordan ran his dock along the other setback line facing the other way. By unrelated circumstance, the dock was pushed toward the other dock, having nothing to do with riparian rights, but DEP wanted Mr. Jordan's dock to extend from this location here in an effort to avoid and minimize mangrove effects on the property. So in addition to the two docks being just the strangest looking thing in the world, it's augmented by the fact that Mr. Jordan's dock was pushed so far north to avoid resource impact.
Andy, this is Steve. Was Latches raised as a defense because it'd been there so long?
Latches was raised in defense, as was waiver. One thing that I left out, and I need to go find that slide. Most of the docks in this picture and that picture destroyed in 2004 because this was essentially landfall for Hurricane Francis, and about 21 days later, Hurricane Jean. And I do have an aerial picture from early 2005 that shows most of the docks in this picture, particularly this one and this one, and this guy down here, are just in a shambles, and there's not much left of them. So they were in getting them rebuilt at the time that Leiden and Jordan were applying for the permits. The department, faced with the conflicting riparian lines, they had received a riparian line that essentially just restated this dock's original permit from a long time ago. And then they had the conflicting riparian lines of Leiden and Jordan going this way. The department did what the department's policy is for some time, which is correct, which is that we do not decide title. You're going to have to go fight this out in court, and until then, we're just not going to give you a permit. Go fight it out and come back to us, and we'll decide from there. And, oh, by the way, we have a standard clause in our approvals that states that if this guy here's dock is ever found by a court by final adjudication to be violating somebody's riparian rights, it's got 30 days to go. So with that, the three parties here were sent off packing to court, and it never got past the summary judgment stage on the location of the line because they reached a distinction here. But the waiver and Latches arguments were raised and were rejected by the circuit court.
Andy, when that first of the southern four docks was rebuilt, I could see it was at a different angle. It showed at the other aerial, more recent aerial that you showed. But this one kind of comes off on an angle, and then the other one looks straighter now and more aligned with the ones north and south.
It could be, but you may not be looking at the same dock. It looks like one dock was not rebuilt.
Okay. So the one south, the two docks there?
This one?
Yeah.
That could be. Yeah, that dock was a little extreme, and it looks more like this dock now.
Yeah.
But again, this dock, when I went out there after the hurricane, this dock looked like a roller coaster track. The pilings had been lifted out of the bottom, and the dock just kind of had a wavy look to it. So it was pretty much done. So Leiden and Jordan gives you an example of how over time the lines, the location of your box can change based upon changes in the law, changes in the accepted practices and conventions of the professional communities, particularly the surveying community. But what happens when you have both the change in practices and conventions and a drastic change in the shoreline itself? After all, we have a rule that says that the lines should be set based upon the orientation or shape of the shoreline and arm of the sea. So I'm going to show another slide, and I'm going to hope that Chappie doesn't get PTSD from seeing this one. But this is a case that we call Della. So this is in Isla Morada. And this is quite possibly the strangest brain teaser of a case that I've ever seen in terms of locating the line. So this is an aerial on Lower Matacumbe Key. We had another slide, but we were trying to limit them. But what you're not seeing is that there was a jetty installed south of here in the, I believe, the late 50s, early 60s to protect a channel that services this canal, this artificial canal down here. And the effect of that jetty was dramatic. What you see here is this thick line running along here, And that is the edge of the plat, which on the plat said mean high water line, in 1952. Now, I'm gonna back up a slide because you see these other lines coming out here, and those are mean high water lines over time between 1952 and 2000, and I believe 17 was when this case finally resolved. So, looking at it on a straight aerial, I see the GCY logo at the bottom there. This was a very interesting exercise to take this line and figure out how we get riparian lines from there. So the problem is that if your riparian lines were to remain static in light of the channel changing over time, you could wind up with a scenario where, for example, this property owner here, lot 39, would essentially become cut off. These lines on some of these lots would literally join and meet, and that property would cease to grow as the shoreline grew because, of course, the riparian owner, one of those rights is the right to receive accretions, just like it's the right to bear the risk of losing to erosions. So you gain or lose based on that. So as this land accretes by a process that is not due to the action of the riparian owner, that's also a very important point, these riparian properties grow inch by inch. And as they grow inch by inch, the riparian line essentially concretizes into a property line moving out, and a new riparian line goes anew into the ocean. And as we know, the method for setting lines has changed over time. So, for example, we have a riparian line. It's hard to see on this area, but you see these light blue lines. This was a disclaimer of interest. It was given to Lot 37 back in, I think, 1980. And the surveyor that did it at the time did it by simply prolonging his lot lines. The reason it was disclaimed was that the shoreline had accreted so dramatically. So 37 had re-recorded his legal description on his lot and had appended his property into his lot with this line running this way. Well, we've already talked about that extension of the lot lines is not favored by the courts or the surveying community in preference for other methods. However, what we also had complicating factors here was we had this odd duck down here. Now, this thing here with the brick pattern on it, which you can also see on that drawing, although it is harder to see, you can see it in here. This was a trustee's deed given to the then owners of lots 39 and 40 that was based upon what had been referenced as a bulkhead line in the application, although no bulkhead line had ever been actually set in this location. The trustee's deed was issued to these people in, I think it was 1967, if I'm remembering correctly. I can read this when it's on a much larger screen, but my recollection is 1967. And as you can see, in 1967, the line that was drawn was from the corner line of the platted lot out here to this dashed line, which they're saying is a bulkhead, which DEP ultimately confirmed there was no bulkhead. But in 67, that's what the trustees gave these two landowners. Well, here came the rub. This landowner, lot 39, bought lot 38 and decided that he wanted to market lot 38, and to do so, he wanted as much square footage to market for his oceanfront lot when he flipped it, in essence. So the obvious thing is, well, you've got this crazy triangle sticking out here, and, well, 39 isn't going to give up his square footage to 38. Now, to show you how foolish this case actually is, as you can see, nobody's really building anything out here And the reason for that is that, the city of Isla Mirada prohibits any substantial construction, out in this location, because apparently this is like the only turtle nesting beach in the Florida Keys. But in any event, this lot here, lot 37, was intently interested in this side of the lot because, much of the house and the view, had been coordinated in this effort, and lot 37 through, events, weddings and receptions and whatnot out on this beach, which was crazy. It looked kind of like Tahiti, rather than the Keys when you looked at it with the big, long beach and the palm trees. So they were fighting over this line. There we go. So, lot 39/38 wanted to draw the riparian line from here. And we kept saying, well, that's fascinating, but that's not where the riparian line comes from. If anything, you draw the riparian line here. The question is, well, why is that? Well, we went and did some very interesting aerial reconnaissance and looked at the historical aerials for the area, and what we discovered was this line here is the shoreline in 1967. This line here was the shoreline in 1970. That meant that everything that you see in this brick-colored portion of the trustee's deed was already dry land accreted to the riparian owners at the time that the trustees deeded it. Meaning that lot 38 already owned this triangle, and lot 39 had no claim to this triangle. The only thing that was actually conveyed in reality by the trustee's deed would have been this sliver out here. The other issue that we had was that as the shoreline changed from a cove method, where you had pizza slice type riparian lines, it had become a straight line shoreline. And so the question was, well, what do you do about the riparian lines? Technically, the surveyor and I had debates over this, I don't know how many times, about the fact that the lines would technically, if you went out and surveyed it every day, would look kind of like bananas or something. They would look like arcs. They would change angle gradually, inch by inch, going out as the shoreline changed shape. But that's not very practical. So what you're seeing here is the changing in the orientation of the lines. There's actually out to there, and then there's actually a slight change here, and then a slight change here, slight change to here, slight change, slight change, slight change. Many of these lines came from aerials. Many of these lines came from actual surveys. So we took the available data and extended the riparian lines, changing their orientation, each of them with the shoreline. And then ultimately, 38's riparian line should not be drawn here. It should be drawn down here, and it should not follow a shoreline, because they wanted to draw it essentially like that. They wanted to basically take as much of this, and then they wanted to take this line and draw it that way. And we could say, no, technically the line would kind of go in a fashion like either that. That was a solution. This was a solution. Ultimately, what we got into was the judge expressing a great deal of reservation about what happens when I set the line here between you and you. What happens to all these other people down the road? Are we going to have a domino effect of litigation? Should these people be in the lawsuit? And at the end of the day, the two parties reached a strange resolution. They set the line in a configuration that looked something like this one here, in a judgment. That judgment was entered in the court record, and the very same day that the judgment was entered, this line here, a quitclaim deed was issued from lot 38 to lot 37, transferring that land back over, so that it did not disrupt lot 37's access easement, They had an access easement that ran along this side of the property because Lot 37 also owned a lot directly across the street on the canal. And it did not disrupt the events that were being thrown on the beach, on the property. So in essence, they agreed to a lot because suddenly, realizing what was going on, this fellow became really, really concerned about this fellow. And if he agreed to a line that made 37, 38 right, he could potentially have 40 coming after him. So he wanted a line in the court record that would keep 40 off of him, but he was willing to give the land right back, essentially in a deed, so that 37 could record it and everybody's title could be quieted in that way. A really, really strange result for a really, really strange case. But that is an example of how complicated the question can be about where the box is.
Slightly less complicated riparian right dispute over where the box is. This is a case called Briggs v. Housens. It is currently pending up in Duval County. And the background is this. This is obviously the Briggs dock. The Briggs purchased this home in 2016, basically in September of 2016. When they purchased it, this dock was not here. Leading up to September of 2016, the owner of this house, the Housens, had been in discussions with the department. They had filed a permit application to build this dock. And the department, I guess being uncomfortable with the closeness of this dock and then this multifamily dock here, asked the consultant for the Housens to obtain a riparian line survey. And so the Housens hired a surveyor to perform a riparian line survey. And although this is not the survey, this is not the exact survey they had, this survey...
This is the Housens survey with the actual docks laid over the survey.
Correct. This is actually an as-built riparian line survey. So in other words, this was done after the fact of this dock being built, and this survey was one that we actually hired a surveyor to perform. What we discovered as we went through the discovery in the case, though, was that prior to the Housen dock being constructed, the Housen's consultant had actually hired this very same surveyor to perform a riparian line survey, and this was the survey that he came up with. And so prior to building the dock, they had the riparian line survey in their hands. And they turned that survey over to DEP. They turned it over to DEP and said, look, you all relied on a bad survey for the multifamily dock to the south, and so, we should be able to build this notwithstanding the survey. DEP said no. And so rather than try to, change the configuration of the dock so that it wouldn't be crossing the riparian line, the Housen's consultant simply withdrew his permit application, reduced the square footage of the dock so that it would not need a permit, and then proceeded under a self-certification. And so the dock is being built in September of 2000. Andy, did I interrupt you? No. The dock is being built basically the same day they close. Pilings get dropped off in the front yard of the house here. 5 days later, Hurricane Matthew hits and floods this house completely, so that basically makes it uninhabitable. And so over the course of the next 6 months to a year, the Briggs are rebuilding their house, and so they're not there every day. And then one day they walk into the backyard and they see, a piling being sunk right here. And they say, what the hell? They start going to DEP, and DEP says, well, we can't really do anything. This is there's no permit, so you're going to have to take it up in the court system. Ultimately, we have done that. We are proceeding with that. They have now, they being the Housens, have now sued the condominium association here, basically alleging, if we have to remove our dock, you need to move your dock. They have also, the Housings have also asserted the laches defense that Steve mentioned earlier in relation to the Leiden and Jordan case. We have answered the laches defense basically with by saying that they had the survey in their hands. They built it knowing that it was crossing the riparian line, and so they can't assert the laches defense. I feel pretty good about that. We will see how it turns out, but that, like I said, that's an example of a pretty obvious dispute over where your riparian line is located. The one other thing that's interesting, and we haven't raised this, but if you see this little cutout here, that is actually a man-made basin. This, if you go back to the plat, which was recorded around 1940, it's clearly labeled as having been man-made and dedicated and whatnot. And so there is, some thought that depending on how you would allocate the private lands here among the three owners, the Briggs, the Housings, and the condominium association, that there is a potential that this dock is actually partially built on land owned by the Briggs family. But it wasn't a case where it was really enough to matter, so we have not raised that issue in the case.
All right, so we're going to now assume that, even though you can see how difficult it can be to draw the box, but that we have the boxes drawn, we have the riparian rights, everyone agrees on that, but there's something happening inside someone's riparian area. And as Andy mentioned earlier, anything going on, even inside someone's riparian area, that's an interference with other people's riparian rights. And so the question has to be asked, and I think it's funny that they use this Titanic type picture, I guess, to say that someone's just going to burrow through. But the question has to be asked is whose interest or whose box wins. And so, in setting this up for the next slide, the idea here is the boxes are not, no one's crossing over and building something like in the Briggs case, someone's building in someone else's box. Everyone's inside the riparian area, but as time goes on, and as the boxes get bigger, there are other considerations as the projects get bigger, and so the interference gets bigger. And usually these disputes can be settled by, setbacks. DEP has setback rule of 25 feet, and there's also a 10-foot setback for marginal docks, and that can chill some of the disputes, but that's not always the case, especially when the setback rule is not in place, such as the next slide, which is the Pearl and Voss situation.
So we put two cases together here, both of which were handled by the firm. By the firm at about 10 years apart, that show two extremes of battle of the boxes or which box wins. So the first case is the Pearl versus Voss case. This is the first extreme. You have two lots, two pieces of property here. Mr. Pearl on the top side, Mr. Voss on the bottom side. These docks already exist. This dock is here first. This dock is here second. Both docks have been there for a substantial amount of time. The properties in this location, which is in Manatee Pocket, along the St. Lucie River, which is a very densely developed shoreline. The properties in this location are each 50 feet wide. So as a result, the old fallback of the DEP setbacks of 25 feet do not apply here. The Pearls have a submerged land lease and run a 10-slip marina out of this facility. They have some large boats that dock here and dock side to, and then they dock some small center console boats inside this L-dock. The Voss property is a lot with an aluminum shed and a wood deck, and a 160-foot dock with an L head on it. Mr. Voss typically moors 1 to 2 boats on this side of the dock, in part because the neighbor further down here on the other side of Voss has been for some time actually violating the riparian line with a boat lift because he also has a 50-foot wide dock. This is an example of greater and greater pressure being placed on the same amount of riparian property and the conflicts that arise. The parties do not dispute in Pirtle versus Voss the location of the riparian line. So in this instance, Mr. Voss becomes convinced that boats from the adjacent Pirtle dock should not be able to cross to any degree the riparian line between the two properties here to get in and out of the Pirtle dock. That all of that must be controlled on Pirtle's side of the riparian line. As a result, Voss submits a application to verify an exemption to place 1, 2, 3, 4, 5 mooring pilings spaced 20 feet apart, approximately 24 feet off of his dock, directly on the riparian line. Mr. Pirtle comes home and finds that. To give you an idea, this space from the end of the L on the Pirtle dock to this piling is 7.5 feet. 7.5 feet similarly from this piling to this piling, and so on and so forth. So Pirtle understandably challenges the Voss verification of exemption. It goes to an administrative hearing. The result of the case is kind of interesting. With no DEP setback in place to kind of set the rules of engagement, you fall back on the underlying riparian rights common law doctrine, which, as I said at the beginning, is that everything that you do in your riparian area interferes with your neighbor to some degree. And it's only when that interference becomes unreasonable that the interference by your neighbor can be stopped under riparian rights law. DEP has given us, thankfully, a great deal of reliance, expectation, predictability by setting setbacks that we can all abide by in designing docks and governing our forward. But the administrative law judge points out in the Pirtle case, in essence, that and pointed out at the hearing even more so that no one has the right to fence off their riparian area. When he looked at Mr. Voss's arrangement, essentially the only thing missing here was barbed wire, going from piling to piling. So the long and the short of it was, the judge found that there was no need for 5 pilings. Mr. Voss had not demonstrated a need. He only moored boats in the 40-foot range. This was a slip designed for an 80-foot plus boat. It only had 2 feet of water. Voss testified he had no inclination to get any kind of boat like that, and that between the lines, he just wanted to keep boats from here out of here. It was found that the riparian rights had been interfered with in this case because virtually no boat could pass through this fairway. This choke point was so severe that even if you look at small flat fishing skiffs, they're routinely at least 8 feet wide. And you didn't even have that in this location. I think the turning point was during the trial, the department actually sent field staff out in a 20-foot center console boat. They had to put the boat into neutral as they approached this point, and then had to physically hand the boat down this fairway, and then hand the boat around to get it into the dock. The maneuvering under engine was absolutely impossible. Somebody almost fell in the water. The whole thing was on video and was played at the hearing. After that, the department correctly pointed out, I think a very telling point, which is that things look different on paper very often than they do when you finally see them. I'm always struck by how much closer things are when you go to the site, you look at it, compared to looking at it on an aerial or on a survey. And the department, looking at this, didn't really, think much about it. It was a bunch of pilings. It was in this riparian area. But when they went out there, the reaction was, oh boy. And we've seen a few of those oh boys over time. I think everybody has, kind of surprised and maybe under the radar. That's a lot closer to what I thought it was going to be. So at the end of the day, the Pirtle case is an example of you cannot completely obliterate a person's vessel access case, vessel access to a dock by fencing off your riparian area. Ruling in Pirtle is largely fueled by a combination of the severity of the impact on the Pirtle property combined with the evidence that indicated that the activity that was causing that impact was really more than was actually needed for anything. It didn't really serve a purpose other than the unstated one of blocking access. So, an example of bad facts making bad law, we put Pirtle at one end of the spectrum. So, we go to the next case, which is the other end of the spectrum. This is a case in Singer Island. This is the Sailfish Marina Resort. Folks in Palm Beach are all chuckling because this is a long-running dispute between these two marinas here. This is Peanut Island off to the left. The Lake Worth / Palm Beach Inlet is basically a few hundred yards south of this drawing, which makes this a very desirable location for marinas and large boats. The Viking boat building facility and Rybovich are virtually 500 to 1,000 yards to the west on the other side of Peanut Island. Half the boats at both of these marinas are Vikings or Ryboviches. Sailfish Marina is an example of the Battle of the Boxes when the very common theme of the desire to increase your activity within your footprint increases impacts on your neighbor and vice versa. The Buccaneer condominium, which is up here, has a dock been in place since about 1958. The Sailfish Marina has been there about as long, but this existing north dock was built in about
86.
86. Thank you. The Buccaneer has desires to increase its footprint as well, and so it's obviously eyeballing what's happening around it. The Sailfish has followed the trend that you see in a lot of marinas, which is that bigger is better, especially when you're across the water from Viking and Rybovich, and so it's actually more lucrative to have fewer slips for very large boats than it is to have lots and lots of small boat slips. With the advent of dry storage and the cost of wet slips, you're seeing this as a trend coming forward. The Sailfish desired to demolish this north dock and to build what you're seeing here, which is a single loaded dock with all the vessels pointed in towards its existing marina. No mooring would be allowed on this side of the dock, which is the north side facing here. What you're seeing is the Riparian line in this location. The parties agree as to the location of the Riparian line. There's no dispute. So once again, you have parties with their docks and their mooring happening within their boxes. However, the Buccaneer has raised the argument, oh, by the way, this is the 25-foot setback here. Now, it's a little hard to see on this photo. I looked for a different exhibit, but this would be the new sovereign submerged land lease. It follows the dock. The new Sailfish North Dock would begin at the edge of the lease, which is 35 feet south of the Riparian line, out to a distance of about stays at 35 feet right here. And then when we get offshore of the Buccaneers' existing dock, it jogs up to the 25-foot setback and runs out. No mooring signs, handrails, the whole shebang on the north side. The prior lease for the sailfish actually starts 25 feet from the riparian line and runs at something of a diagonal down this way. It's not parallel to this riparian line, and then meets here. So it goes from 25 feet at the waterward to 35 feet back at land. In reality, this dock is, for instance, in this location here, several feet further south than the prior lease that was already in place from the state of Florida. The lease for the sailfish was at most instances 35 to 36 feet off of the riparian line. Here, the Buccaneers lease, which you see here, is at its shortest 34 feet here, out to, I think it's 39 in this location. I think it's 37 right here. So the Buccaneer has a dock which all of the experts that we invented provided evidence was built at a much earlier time for smaller boats. And this is an example of trying to park an RV in a single-family garage. These large boats are virtually crammed in these slips. The finger piers, or the mooring pilings between these boats, are in many cases split like a pitchfork between the bows of these boats as they come in, and the bows of the boats come right up to the lease edge. The Buccaneer lease cannot be increased in size for this dock, grandfathered in. So this is an example of maximizing your riparian area. The Buccaneer had an issue with this arrangement because they have for some time been mooring 60 to 65 foot sport fishermen, particularly in these west slips. And the sport fishermen would leave the slip, come south toward the sailfish, and to turn around, they would either put their bows into empty slips on the sailfish's side, or even in the space between boats, they would put the pulpits of the boats in, and then back out, and the same maneuver coming in. No one disputed that either side had the right to cross the riparian line to get in and out. Indeed, that's what setbacks are for, to give everybody a expected space of open water, a minimum of 25 feet here and here. In this case, everybody was operating with much larger, more in the neighborhood of 70 to 72 feet. However, the the Buccaneer was making the argument that its riparian rights of access very, very large boats, and to actually cross into area that had been under lease by the sailfish for several decades, and that the sailfish was required to keep this water within its riparian area, within its lease, and inside, or I should say on the sailfish side of the setback, open for the neighbor to use, essentially dedicated to the neighbor's use. The case, it was also undisputed by all of the experts that with the new dock in place, the Buccaneer would have no problem getting 50 to 55 foot boats. 60s, 55s, in fact, the evidence suggests they're probably already too big for the situation they were in, and it would be slightly harder. At the end of the day, the administrative law judge and the department found that no one has a riparian right to dock a specific type or sized boat at a specifically arranged dock. You have a right of access. That access, the cases actually say, talks about riparian access in front of your property. However, it is recognized in a number of cases that people cross the lines. You're not allowed to exclude the public from navigating unless it's absolutely necessary. And even then, all about the paramount right of the public to navigate. The judge found that the right of the riparian neighbor did not include the right to go into a leased area preempted by his next door neighbor and to demand that be held open. Judge also found that this was not a navigation hazard under 1821 ERP rules. Both of these cases give you extreme. The Titanic image in the beginning is actually kind of a joke. We kept talking about aircraft carrier Nimitz or whatever, and when does it stop? If the Buccaneer docks, Queen Mary on this dock, would the sailfish have to accommodate that? Where does it end? So as these types of cases, the whose box wins, are really the types of disputes that we are seeing rapidly increase, particularly right now as you're seeing a lot of redevelopment of marinas and alterations of existing docks, more so than new docks. As the activity intensifies, the whose box wins is probably the challenge that you're going to see the most of going forward.
All right. I was going to say that we are going to conclude by mentioning some updates or changes. These will likely be discussed further at summer school for those who are attending. But there was some changes to 18-21 of the code back in March, and there were some impacts from that. We're just going to highlight a couple, particularly setbacks and the definition of the marginal dock and the implications from there. But go ahead, John.
So the first of the changes is that the 1821 1821.0043D, which governed the setback requirement, it has, throughout my practice, has been the case that the setback could be waived to avoid resource-related impacts. There has been some language grafted onto that now allows the department or the board to waive the setback in the public interest, which is a little bit different. We haven't, obviously it's only been, I think it's been effective since mid-March, so we haven't come across any examples of that becoming an issue yet, but that's something to look out for. The other area applying to setbacks that has changed, and I'll give you an example of what would not be allowed now under the new rule. The consent by rule provision, 1821.005, it is, I think, 2B. It used to be that if you had an exempt dock, you did not have to meet the setback requirement. And so, for instance, this case right here, this is the Briggs case. This dock is under 1,000 square feet. It has about 14 feet between here and the riparian line here. That was fine under the old rule. With the new rule, even activities conducted pursuant to consent by rule have to meet the 25-foot setback. And so basically this is now a grandfathered structure, and if this person were to come in and try to re-permit this dock today, they would be unable to do so. Or excuse me, if someone claimed the exemption and built this dock, it would be subject to removal because it would not be authorized pursuant to consent by rule. You would actually have to file a permit to build this, file for a permit to build this dock, and you would be unlikely to get it because of that setback issue right there.
The housing dock would presumably not apply to that, given the fact that it appears to be less than 50 feet of shoreline, and according to the new rules, less than 50 feet of distance between two riparian lines in the location of the dock.
And then finally, the definition of marginal dock has been amended to basically provide that it cannot, a marginal dock is no further than 10 feet from revetment, and so it, I guess, eliminates the situation of where you would have if you were to add mooring pilings or a lift onto it, it would likely have to be wider than that, and then it would come back, and so it would probably have to qualify for the 25-foot setback as well under the same reasoning.
This is an interesting interplay here. By introducing the 10-foot limit on extension of a marginal dock into the water in the rule, there's a strange interplay between the definitions, because a marginal dock is defined as a dock running parallel to the seawall. Then you look at the definition of dock, and the definition of dock in 1821-003 expressly includes mooring piles, boat lifts, platforms, catwalks, any portion thereof. What's changed is that the marginal dock regulation now states in it that it's limited to extension 10 feet water. But unless there's something clarifying the relationship between marginal dock and dock, the minute you strap a boat lift onto that dock, you're extending more than 10 feet of water. The minute you add mooring pilings, they're part of a dock under the definition, and the 10-foot setback from the side riparian lines that normally have applied for a marginal dock may not apply anymore. This is one to watch going forward. I've not had the opportunity yet to pick the department's brain on that one. I think it's a question going forward. I know that everybody's been waiting for changes to 1821. I would joke with Tim Rock all the time before Marco. He would always do an update on the DEP rulemaking effort at the end of the sovereign land presentation. The update was we're still working on rules. So we're all very excited because Tim will actually have a lot to talk about this summer with all these new rules. But I think that this is an interesting one to watch, because I think you have a lot of things that were a no-brainer, marginal dock, 10 feet off the side setback. Very easily you could run afoul of this change. It's not clear to me whether it was intended or not, but it is.
So, question?
Yeah.
So potentially, you could get a permit for a 9-foot wide marginal dock that only has 10-foot setbacks, and then later, if you wanted to come back in and wanted to add a boat lift or something on the waterward side of that,
you could run into a situation.
It may not be allowed because it would make that entire structure a non-marginal structure, and therefore would have to.
That's actually another example of that. And I think that the answer to your question is yes, it would no longer be a marginal dock. But say that you have a dock that extends. It starts 25 feet set back on one side, but then it extends 10 feet set back on the other end. But all of that dock is 9 feet out. But you want to add the boat lift to the end that is 25 feet back. So the boat lift would have been 25 feet set back. The rule appears to me now that although before you could do that because the boat lift is not encroaching or a hazard to your neighbor, but now all of that dock would have to be torn down and moved to 25 feet set back if you wanted to add that boat lift.
15 feet of it.
Yeah. The part in the setback, or the 25 foot.
Yeah.
Yeah.
That seems to be what the rules suggest, and I don't know whether that was, what DEP is going to do in that situation, and I don't know that it was intended.
I would be very surprised if they interpreted it in that way.
I don't think they did, because it's not in the rule itself on the marginal dock rule. It's only when you read that a marginal dock is a dock, and then you have to go to the other definition of dock. And it was never a problem before because we didn't have the 10-foot limitation out of the water.
I can tell you that yes, DEP in some fashion has taken that position that if you have a marginal dock that's 10 feet set back and you want to put a boat lift out there, even though the boat lift would be 25 feet set back, the part of the dock that is up to the 10-foot would have to be removed because it's no longer a marginal dock.
What if they were structurally separate?
So, don't give away our playbook, we probably have. That sounds like Steve Lewis's, tilted, or stilted pool idea from a few years ago. A structurally separate pool elevated on stilts. So, yeah, we could have the lift on 4 posts.
All right, well, we want to say thanks for everyone attending. If you're remote, you're signing off. We appreciate you listening in.